After a divorce, you start a fresh chapter of your life. One key step to take at that point is updating your estate plan to reflect your current circumstances. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. In this video, I'll share tips for estate planning after divorce. If you previously created an estate plan with your ex, your trust or will becomes null upon divorce. Other documents may still be valid, but should be replaced to reflect your current wishes. Once your divorce is finalized, you should be sure to update the following documents: your revocable trust and or will. Most people choose to remove their ex as their successor trustee and or executor, and remove them as a beneficiary of their estates. Your advanced health care directive should also be updated. If you no longer want your ex making end-of-life decisions on your behalf, or consulting with your physician regarding your medical care, you'll need a new advanced directive that appoints new agents. Your durable power of attorney. If you no longer want your ex making financial decisions on your behalf and getting access to your financial life, you'll need a new durable power of attorney that appoints new agents. If you have minor children, you can name a guardian for them life in your will or your trust. But be aware that if you were to die, your ex-spouse will likely serve as guardian of your minor children unless the court determines they're unfit. If your ex-spouse has an addiction or substance abuse problem or is abusive, name someone else as a guardian of your minor child in your estate plan. Consider setting aside some money for your successor trustee so that they can access it if needed to go to court and prove them unfit to serve in that role as guardian of your minor child. If your ex-spouse serves as the guardian for your minor children, if you're to pass away intestate, meaning you did not leave a will behind, and your ex-spouse becomes the guardian for your minor children, without anything else in place, they also would control any inheritance you left for your children. The way to fix that is to set up a revocable living trust. That way, a trustee can be appointed for your minor children's inheritance, that they can manage the funds for their benefit. Another question often asked is, can you continue to use the same estate planning attorney you used prior to your divorce? Let's say you previously created an estate plan together with your ex-spouse. If your ex is willing to consent and sign a waiver, you can hire the same attorney to prepare your separate estate planning post-divorce. If your ex won't sign a waiver, then you'll probably need to find new legal representation. Whether you stay with the same attorney or find someone new, be sure to give a copy of your divorce agreement to your estate planning attorney. This document will outline any legal obligations that you may have to your ex-spouse after you pass away. Be careful to meet any obligations outlined in this document, such as requirements to maintain a life insurance policy. Failure to do so may result in litigation after your death. Your divorce and/or estate planning attorney can review these legal obligations with you. Beneficiary designations also need to be updated post-divorce. Not all assets are distributed by your estate plan after your death. Some assets are simply distributed to the named account beneficiary, including the following assets: life insurance policies, retirement accounts such as IRAs and 401ks, payable on death or POD accounts, transfer on death brokerage accounts. After a divorce, check your beneficiary designations on any such accounts you may own. To update your beneficiaries, contact the institution and request a beneficiary designation change form. If the time comes when you plan to remarry, be sure to meet with an attorney and draft a prenuptial agreement once you get engaged. Prenups are an important document to create prior to any marriage, but are especially important if this is your second or more marriage. Navigating estate planning after divorce may seem complicated, but an experienced estate planning attorney can guide you seamlessly through this process. If you have any questions about this topic, please feel free to contact our office. Thanks.